All right, so my presentation essentially is on data communication responsibilities for cargo care in autonomous ships, and we use a charter party perspective. All right. So I'm taking the common law perspective to this. So now, the context of this presentation is the fact that common law assumes ship owner control, in the sense that conventionally, the ship owner is assumed that the ship owner has a responsibility or is in a position to be able to assess risk, to mitigate the risk, and to respond to the risk. And then the main context in this regard is that autonomous ships decentralizes these systems. And just because of the technology, cargo care is mediated by real-time data, and it then becomes pertinent that contractual dynamics are adapted in that regard. So the entire thrust of this presentation is to look at how we can adapt already conventional norms, information norms that are involving timeliness, accuracy, security, and confidentiality in the mass context. So, I mean, as Lucy yesterday and Barbara has already done, we have a lot of promising developments in mass. You've got the Yara Berkland, which is estimated to take about 440,000 trucks off the road. You have ASCO, that is aiming to take out about 800 trucks off the road. You have the Meguri 2040 in Japan. You have the trials going on in Singapore. You have CAST in South Korea. And one thing is evident. What is evident is the fact that mass is moving from something experimental, nearing more commercial deployment. So it is quite germane that contracts must evolve. So now the legal problem here, as I mentioned earlier, is that carriage of goods law assumes that the ship owner has control. Now, ship owner controls navigation and cargo care, and charterers must provide cargo and freight in this context, right? And then this is the common law assumption as well. But then the good news is that the law is very well settled that parties can use contractual clauses to displace this responsibility. Now, mass disrupts this because decisions could be made by AI, sensors, and at remote centers. And so it's quite pertinent that, or it's inevitable that there is continuous data exchange where both parties could be involved in both monitoring and responding. Now, there has been a lot of regulatory efforts, as Barbara already mentioned, especially at the IM1 EU level. But unfortunately, most of these focus on public law issues, so involving safety and liability. But then a more focused consideration on the impact on contractual balances and imbalances there's a huge gap in that regard. So this is unexplored fertile ground, and here I am being the farmer and trying to see how we can explore these issues. So now, just to narrow my scope, just for the purposes of time, I have narrowed the scope of the consideration. So first is that I'll be using void charters as a premise, because relative to the other mainstream types of charter parties, like time charters and demise charters, void charters have the clearest division of responsibilities between ship owner and charterer, and that's conventionally. Also, I'm also taking the short-term temporal view to this. I'm looking at the next decade. Of course, in the next perhaps 50, 60 years, yeah, things will be much more advanced. But I'm looking at a time where there'll be cooperation between both conventional vessels and autonomous vessels. And then one other thing that has also inspired this context is the fact that when you look at the economic and business cases surrounding, for example, the Berkland or ASCO, the idea is usually for point-to-point, short sea shipping for point-to-point voyages. So again, operationally, these things are much more suited for voyage charters. So I'm trying to see how we can learn a few lessons from this immediate use case to see how we can extrapolate to broader context, perhaps also inspiring the regulatory approach to these issues. Okay, so at common law, the shipowner's duties conventionally, and when we apply the alongside rule, in quotes, conventionally applied to loading, storage, carriage, and discharge. And again, as I mentioned, this is anchored in the presumption of control. So they are in the position to avert harm. And this is confirmed by plethora of case law. You have Brace, you have Stewardess, and this duty, of course, is a continuous warranty. So the rationale is that the ship owner is the central authority with foresight and, of course, precautionary power. And then the logic is that cargo care should follow, or cargo care obligations should follow the actor with the most control in that context. So if we're then meant to extrapolate it to the autonomous ship context, then I mean, logically, we then have to see how these things can change if the incident of control should shift, or where both parties have fairly equal instances of control. Okay, conventionally, in terms of modern shipping, and I've had the privilege of having to consult for a few companies in that regard, is that modern shipping is quite modern, forgive my repetition, because currently, for example, if you look at loading operations, there's a lot of use of autonomous technology. So you have automated gantry cranes, you've got sophisticated software, you have GPS technology, you have remote controlled centers, and so there is a huge interaction of automation in that process already. Same thing with storage, same thing with discharge as well. And then I did find the Maritime Accident Investigation Bureau report of 2007 involving the Annabella quite instructive. And so what happened in that situation was that you had 7 30-foot containers collapse. And then after the investigation, it was found out that it was as a result of overstacking and an absence of lashing. And one of the conclusions of the report was the fact that, and I'll just read that, as a result of its analysis of this accident and ascertainment of its causes and circumstance, the MAIB considers that there are shortcomings in the flow of information relating to container storage between the shippers, planners, the loading terminal, and the vessel. So this just emphasizes that in modern shipping, it is inevitable that data isn't exchanged between all players in the value chain. And then this even becomes more accentuated in autonomous vessels, especially where research shows that IoT containers, smart containers will be used in this regard. So information is not only collected, but then it must be exchanged and it must flow in an operationally efficient manner. Now, in terms of contractual displacement, generally, in terms of the traditional stages, you've got 3 traditional stages. So you've got the loading stage, where traditionally the charterer will deliver goods alongside the vessel, so AKA, or that's where we have the alongside group. Then you have the second stage involving carriage, which is, of course, the shipowner's responsibility. And this presentation will focus on just this aspect. And finally, you have discharge, where the shipowner again would deliver to the ship side, and then the charterer would come take it. However, this again, common law presumptions, and these conventionally have been displaced. So, for example, in FIA clauses, so free in and out clauses, where this dynamic is seriously altered. So, mass, of course, will take advantage of this legal, would I say, innovation of sorts, to displace these common law obligations. And then I do say that without explicit drafting, courts may struggle to allocate liability fairly. So, for example, if you look at the very popular GenCon 2022 that says, for example, the owner shall care for cargo, for example, we might have to revisit this. I do think it's counterproductive to go and amend existing charter party forms because they're not regulation. Might as well just create new ones, if anything. Okay, so this was, I don't know what I was saying yesterday, but then during COVID, I was almost like a mental patient because of the boredom and loneliness. So yeah, this is one of the things I did during COVID about 5 years ago. I drafted up a sample charter party form for autonomous vessels. So hypothetically, for example, you could have obligations distributed in this way. So, for example, something involving optimal temperature in cargo hold. So, for example, the ship owner's responsibilities could be ensuring proper installation, regular service and maintenance, and maintain temperature control systems. But then for the charterer, it could be perhaps regular monitoring of temperature readings, maybe notify ship owners of any anomalies in that regard. Same thing with humidity, for example. It might be the ship owner's responsibility to maintain humidity and dehumidification, set up systems. For the charterer, it might be their responsibility to monitor these levels or even remotely operate the container. So these things are things that I do believe would be in our near future. So now, then we come to the concept of data. Now, again, in modern shipping, data is important, right? Like I mentioned earlier, data is not only collected, but it should also be appropriately distributed, right? Modern cargo care is very much data centric. So, for example, data around temperature, humidity, vibration levels, and also the use of predictive analytics to say, well, yes, this issue has not occurred, but then based on current trends, we estimate that in the next 6 hours, the reefers would lose the low temperature that they currently have. So in this regard, therefore, for operational efficiency, data usually must be, or compulsorily, must be accurate, timely, and secure. And MAST expands the scope, or MAST accentuates this, would I say, in the sense that more emphasis is placed on the accuracy, timeliness, and security of data. And then you have a lot of parallels around, you can draw a lot of parallels from conventional issues regarding communication of information in conventional vessels, rather. So now, in terms of, generally, in terms of determining data-related responsibilities, again, this presentation just takes a narrow scope just between the shipowner and the charterer. So a few factors that might be considered. I don't know how to take off this black box.
Can only move it on the right.
So if you press it like the line, it will produce.
Yes, yeah.
This one, yeah.
Okay. Okay, perfect. Thank you. Possible determinants of data responsibility. So for example, so 3 things. So first is the adopted cooperation model. The second is sensitivity of data. And the third is technical capacity. So together, this really inspired the allocation of risk and responsibility between the parties. And I'll briefly go through them. So in terms of the data cooperation concept, this essentially just means how would parties come together to define their cooperation dynamic between themselves. So for example, a few things to consider. In terms of models of data cooperation, for example, or one approach could be the access and usage model, where data cooperation is defined from the perspective of who has access to what, who sees what, how does the other party, or how does one party use certain information, and what type of information. This might also involve the joint interpretation of anomalies and also the flexible response to these things. Now, another approach of defining data cooperation could be from a data security point of view, to define responsibilities from the perspective of who has responsibilities regarding perhaps encryption, firewall security storage. And again, this might require a bit of dynamism and flexibility in trying to counter cyber threats. Another model of data cooperation could be incident-rich response model, in the sense where data responsibilities are distributed on the basis of responding to risk and mitigating risk in that regard. And these things, or these models, are not necessarily mutually exclusive, and they can all collaborate one way or the other. But then I would say that these would inspire the data responsibility between the parties. Now, another thing that would also do that is the sensitivity of data. So data can generally be classified into 2. So general data and sensitive data. So general data is data that isn't quite confidential of sorts. So it could be maybe data on fuel consumption or something of the sorts. But sensitive data could be things that perhaps border on cargo specifics, or things that would touch on supply chain secrets, trade secrets, or some proprietary issues as well. So depending on the sensitivity of data, duties or data-related obligations between the parties would be distributed, along those lines. It's quite possible. And then finally, and logically, technical capacity. Because it wouldn't make sense for one party to say, well, for example, the ship owner would be say, well, they're responsible for telemetry, for example, so collecting data and streaming them in real time, when the other party doesn't have access to data analytics tools, for example. So we then have to consider the technical capacity of either party, to handle such data. So depending on those things, depending on technical capacity, obligations involving data could be distributed. So yeah, so that is the TLDR of that. So now let's go down to the start of the show in terms of contractual norms. So what I have done essentially, like I mentioned, is that I have drawn from conventional information-related norms in conventional shipping to see how we could apply and extrapolate to the mass context. So drawing on traditional norms of timeliness, accuracy, confidentiality, and security. So let's quickly take timeliness. So for example, if you look at conventional charter party forms like the NYPE 2015, Supply Time 2017, that emphasize things around timely delivery notices or timely lay-up notices. For mass, again, data communication would be timely or should be timely depending on the nature of the information. Of course, there's information that requires real-time communication, and then those that might not necessarily be real-time. And some lessons to note from from case law, for example, if you look at the Hill Harmony, where there was late communication of deviation from written instructions, or the Achilles on late delivery, or the Lady M on premature NORs, or the RTI case, or the Hapag-Lloyd case as well. What these just go to emphasize is that where parties have agreed, data should be or information should be communicated timely, in a timely manner, and in this context, data should be communicated in a timely fashion. So, so for example, when one is contemplating drafting a mass clause around data timeliness, it might be useful to distinguish between data that requires continuous streaming, so real-time communication. So things like perhaps location, speed, or in specific cargo context, it could be things around what the current temperature reading is, what the current photosensitivity readings are as well. Or it could also be data that's not real-time. So it could be those ones that require event-triggered updates. So for example, let's say the reefer has lost its required temperature, for example, then of course, there might be responsibility to only communicate that when such event happens. Or perhaps periodic reports like daily diagnostics, perhaps every 24 hours or 48 hours. So it really just depends on the nature of the information that parties wish to communicate. So clauses ideally should specify trigger events. So at what point should this data be communicated? The time frames of communication, so should it be every half hour, every day, every month, perhaps we see. And of course, it might be useful to also state the consequences of a breach of this obligation, just to help with calculation of damages in that regard. Now, going on to accuracy, it is not sufficient, in my opinion, it is not sufficient that data only be timely. It must also be accurate, because logically it makes no sense that you communicate or you communicate inaccurate information in a timely fashion. So if you look at maybe recent cases like the Thai price, where the courts made clear that in terms of communication regarding the state of cargo, it is not an absolute warranty, but it is based on honest assessment at the time and when it was communicated. So again, this is something that the charter party clause might need to check against. And then, for example, there are mass parallels in this regard. So, for example, if there are if there is inaccurate telemetry, so the data that is being streamed is inaccurate, then that might have a ripple effect, a cascading effect or domino effect in that regard. However, there are many technical considerations that might trigger this. So sometimes in conventional shipping, it might sometimes it's due to the negligence, for example, of the other party, or it could be due to malfeasance or misfeasance, perhaps something like that. But then in situations involving autonomous vessels, it might simply involve situations of technical issues. So there could be issues involving calibration drift, signal corruption, software errors, bugs that have come with software patches and updates. So it might be necessary for a charter party to not only create a framework for the accurate communication of data, but then should take a step further to consider the infrastructure. That communicates this data. So also clauses can define tolerances. So what is the tolerance for inaccurate data? So it could be maybe plus or minus 0.5 degrees Celsius, for example. You can also mandate redundancy. So when we say redundancy, it means that the data is replicated across multiple systems just for the purpose of transparency. It could also require diagnostics and disclosures. And also, it could also impose correction duty once an error has occurred. So when drafting a clause for this, for example, that the owner could warrant for calibration and maintenance of the data communication infrastructure, could also provide the framework for tolerance and redundancies, as well as system checks and disclosures, and of course, correction duty once an error is found. And finally, the final norm we'll take a look at is the norm of confidentiality and security. Well, so in terms of mass data streams, there might be highly sensitive data. And if you look at modern case law or modern English case law involving confidentiality and breach of data, there's some things to look at. For example, if you look at the Vestergaard case, the court made it very clear that you can only breach confidential information if it is reasonably clear to the party who breached such duty that such information was in fact confidential. So that is one thing to take into account when drafting a data confidentiality clause, to say, well, this is confidential information and it must not be disclosed. And you have similar clauses like that already in Supply Time 2017 clause 26 that has a confidentiality baseline. Now, in terms of the security aspect, there's in terms of, and this is quite technical, that a party must be vigilant. A party must be vigilant as to how they communicate this information, and they must be vigilant and must be aware of the various security risks. So the MAS could require, or the contract could require end-to-end encryption. It could require firewalls and intrusion detection. It could require third-party penetration testing. It could require secure protocols for transmissions. It could require regular audits. And if you look at the very recent case of the Russian aircraft lessor case, yes, where the court made it very clear that that parties must take into account the operational basis of the information that they're communicating. So if it's highly sensitive information, then you need to, more emphasis should be placed on communicating this through more secure channels. So in this situation, they had communicated highly sensitive information through text message, and then that was deemed to be abhorrent of sorts. So when one is drafting a security and confidentiality clause, it could be you could include obligations around encryption, firewalls, secure protocols. Also, the contract should allocate cargo telemetry, perhaps to the charterer, and vessel performance to the owner. Prohibits reverse engineering, informal channels in communicating information. And in that regard, then what we've done is that we've aligned this with the operational requirements of autonomous vessels. So, ladies and gentlemen, I conclude. to say that I continue to say that mass unsettles foundations of cargo care. But then my personal opinion is that yes, changes are very much required. But then I do think that we have sufficient lessons that we could extract from in modern shipping. So no one should panic, in my opinion. And there's a lot of case law that could be extrapolated. And so it is then left to a business-minded lawyer, I guess like myself, if I do say so myself, to be able to take into account these considerations in developing charter party forms and eventually perhaps standard charter party forms in this regard. Now, the underlying thing, therefore, is that maritime practice in general, trade in general only thrives where there is legal certainty. And therefore, that should be the underlying rationale in everything that we do relating to autonomous shipping. So be it contractual or regulatory, we must have at the back of our minds that the players need legal certainty. And I guess, like Bob Marley says, don't worry, everything will be all right. Thank you very much, and that's all my time.